questions if you have any. And I want to appreciate you for making out the time to be here. Okay, that said, let's jump right into it. Today's class is titled Banker Customer Relationship. Banker Customer Relationship. What does banker customer relationship refer to? That is, how does a bank and a customer relate? How do we characterize what happens between a banker and a customer? By the end of this class, we are going to know who is a banker, who is a customer, are there any duties a banker has or a customer has, and how can we characterize, what can we legally say, legally speaking, how can we characterize the nature of the relationship that exists between a banker and a customer? We are aware that there is a relationship between somebody who goes to buy, let's say, bole along the road. If you want to go and buy roasted plantains, there is a relationship you have with a woman who sells roasted plantain. That is a customer and a seller relationship. By virtue of your relationship with this woman who is selling plantain to you, there are duties that arise, as a result of that relationship. However, this is not the case with something that is qualified and technical, like the relationship of a banker and a customer. And that is what we will be getting into today. As students and as future researchers, I expect you to agitate your minds on things of this nature. Okay, moving on. A person who deposits money in a bank has a relationship with that bank. If you take your money, what you've made, your source of livelihood, and you deposit it in a bank, it bears to reason that you have a relationship with that bank. There's something about you and that bank that makes you feel like you can trust them with your money. You do not just walk into anywhere and dump your money. You do not just walk into a bank, drop your money on the floor and take off. You know, you expect that one, when you follow the rules a bank gave for how you should be able to deposit your money, you expect to have that money back whenever you want it, on demand, basically. You may not want all of it. You may just want a part of it. You may give the bank an instruction to keep this money away from you for a time in what is called a fixed deposit account. You say, bank, keep this 1 million naira for me. I will take it in 1 year. That is the nature of a relationship. That is an order that you are giving the bank. There is a reason why you trust the bank to do that. There's a reason why you don't feel like your money will be lost. In fact, I tell you people now, if you knew certainly that your bank is going to go moribund tomorrow, you will collect your money by all means today. You give everything you have to make sure you go there, collect, even if it's 2,000 naira that you have in the bank. And the point is, there is a nature, there's a legal ramification, there's a legal dimension to the relationship that you have with your bank. And that is what we're going to explore today. In order to explore that relationship, we'll be also looking at what a banker and a customer means. So let's go. What does a bank mean? Is the word bank and banker different? Usually people use the word banker to refer to somebody who works in a bank. So you say Emeka is a banker. He's banker, this and that, okay? But is that really what the word means? In banking law, the word banker and the word bank mean almost the same thing. We use the word interchangeably. So if you say a banker's dinner, they expect different banks to be there. Of course, just like every, what would you call it now? Every corporate body, it is represented by human beings. There are no physical banks walking up and down, okay? If we say Access Bank was there, what we refer to is workers in Access Bank were there. But that also means that Access Bank as a corporate entity was there as well. So a bank and a banker, very similar, can be used interchangeably, can be used for the same things, can also be used to refer to people who work in bank, that is informally. But then when I say the CBN is the banker's bank, the banker's bank, that should show you that there is a level of understanding that we have of the word bank and banker in banking law. So when we say it's the banker's bank, we are not meaning that it is the MD of Access Bank's bank. No. What we mean by the CBN is the banker's bank, we are referring to the fact that the CBN is the bank for other bankers. Bankers like Access Bank, Zenith Bank, those are bankers, and Guaranty Trust Bank. When they want to bank, they bank with the Central Bank of Nigeria. So that is the role of a central bank. But I'm explaining what the word bank and banker mean in that context for you to have a broad understanding of the fact that banker and bank are words that can be interchanged, especially in banking law. Now, if we are looking at a precise definition of the word banker or bank in banking law, that all of us will hang our boot and say, yes, this is a perfect definition, we will be wrong. There is no such thing, as you would have been well aware with many things that are legal. There is hardly any legal concept that is fully, exhaustively and precisely defined. Okay, so H.L. Hart defines a banker or bank as a person or company that carries on the business of receiving money and collecting drafts for customers, subject to the obligation of honoring checks drawn upon them from time to time by customers to the amount available on their current account. So Hart is defining what a banking business is and saying that a banker is a person who or a company who does this kind of business. Well, that is quite understood. You are going to find that many definitions take this light, many definitions uh, take this form, this approach, as trying to define a banker as somebody who does banking business. Let's look on. Section 2 of the Evidence Act 2011, not the old Evidence Act E14, no. The old Evidence Act E14 has been repealed. The Evidence Act we have today is the Evidence Act 2011. It defines a bank or a banker as a bank licensed under the BOFIA and includes anybody authorized under an enactment. An enactment is a law or a legislation to carry on banking business. So a banker is somebody that have taken license under the BOFIA. You are going to see section 2 of the BOFIA is precise on how a bank can come into being. So the Evidence Act is saying the BOFIA licenses a person who can call himself a bank, or, and rather, not or, and includes anybody authorized under a law to carry on banking business. So even if it's not BOFIA that authorized you to carry on banking business, if it is another law that authorized you, you're a bank. So that means you don't have to just get your authority from the BOFIA. You could have gotten your authority as a banker from any other legislation. It defines banking business as having the meaning assigned to it in the BOFIA. Banks and Other Financial Institutions Act of 1991. Banking business under Section 66 of the BOFIA is defined as the business of receiving deposits or current accounts, savings account or other similar account, paying or collecting check drawn by or paid in by customers, provision of finance or other such business as the governor may, by order published in the Gazette, designate as banking business. So what do you see here? If, for example, a governor designates, the governor is authorized, right, to designate a particular action as a form of banking business. So why this is an ever continuing, why it is an ever continuing cohort, or rather ambit of the law, is that it's possible for what is referred to as banking business to keep developing. You know, what is referred to as banking business keeps developing day by day. Okay, what is banking business today may not be banking business tomorrow. Okay, so what is banking business today may not be banking business tomorrow. I'm having issues with my internet connection. I'm hearing that, or rather, I can see here that is telling me that my internet connection is very unstable. Okay, so I don't know how it will make sense of this recording, but it's telling me that it's very unstable. Do we have anybody who is still paying attention to this class? Can someone brief me on what they think has been going on? Did you hear me up to this point? Can you even hear me now?
Yes, sir. We can hear you. We can hear you, sir.
Okay, did it go off at any point?
Sir?
Did I go off at any point?
Yeah, yes, sir. Yes, sir. But now I can hear you very well, sir.
Okay, thank you very much. So,
Yeah.
as I was saying, what is banking business keeps developing, right? It's not static, it's something that continues to develop. So moving on, who is a customer of a bank? A customer of a bank is somebody who enters into a contract a customer is ordinarily somebody who enters into a contract to purchase a good or a service. In banking law, this is just purchasing things is not just what a customer is. A customer is not somebody who purchases a product from a bank. A customer to a bank is a kind of relationship that starts from a mandate. Mandate is a contract a banker and a customer enters into, giving the banker authority to keep his money and the circumstances of the contract between him and the depositor. Okay, so if a person has an account with a bank, he is a customer of a bank, he must have an account with a bank to be regarded as a customer of the bank. So the court have declared that a customer of the bank is any person who has an account with the bank, or for a person on whose behalf, right, the bank accepts deposit, collects items, and this also includes a bank that has an account with another bank. It's just right to insist that a customer of a bank must be somebody who has an account with a bank, not somebody who, for example, deposits money with a bank, not somebody who um, collects money from a bank, not somebody who um, works by a bank. Depositing money in a bank, buying products from a bank, allowing a bank to handle your transaction without opening an account in that bank is merely you patronizing that bank, and is not a proof that you are customers. To become a banker's customer, you must open an account with that bank. So you ask yourself, is it possible, is it right that before I become a customer, I must have made an amount of deposits? The law is this: if you've agreed with a bank to open an account, whether you finish the process or not, and you go ahead to give the bank an order to accept deposit on your behalf, you are a customer of the bank. Now, why is it important to characterize yourself as a customer of the bank? You will see that there are benefits which a person who is a banker's customer can lay claims to, especially when the money he has is being questioned, right? When, people, when situations have arisen that questions are beginning to be asked, you never know when something is important until a case comes up. And this is why you, as a lawyer who is learning this, will be able to advise the parties in cases that disputes arise on what is the nature of the rights and obligations that their relationship legally pertains to. Okay. I want to ask you these questions, but you can reply me tomorrow evening. That is, does receiving checks steadily from a bank make you their customer? Now, what does this mean? Imagine that you are working for somebody and the person gives you a check from from GT Bank. Say, go and cash this GT Bank check. You've cashed this bank check for the past 4 years. You just go there, you collect your money from them. Are you a customer of that bank? Now, if you open an online account and you've never made a deposit, all these online banks today, you just open an online bank, you've never put any money inside this thing. Does it mean that you're a customer? The people presenting tomorrow should address me on these two questions. Moving forward, what is the nature of a banker and customer's relationship? The first thing that comes to mind is that it is a contractual relationship. It is a relationship that is contractual in the sense that there is a written request for a customer, from a customer to a banker, telling the banker the nature of the account he wants to open, the circumstances he will be bringing money into the account, and also what the banker thinks he can do for the customer. For example, there are banks that believe that they will charge you 200 naira for every transfer you make. It will be put in the things that you are supposed to agree to before you open an account with them. They are giving you their terms of service. There are banks that don't give you any benefit for depositing your money with them. If you like, keep your 1 million with the bank, you will not get a kobo from them. There are banks that will once in a while give you benefits. They are going to tell you the nature of account you can open to receive these benefits. They, they can tell you, okay, under this account, you don't ever um, get to pay for any of our service charges. You know, a contract is important. Contractual relationship is the foundation of a relationship between a banker and his customer. Going forward, what other way can we characterize the banker and customer's relationship? It is also the relationship of a debtor and creditor. Who is a debtor? A debtor is somebody you've handed money to. The creditor is the bank, is the person giving the bank money. So you as a customer, your money is in the bank. The bank owes you your money. If the bank refuses to pay you your money, you can go and through court action for money had and received, force the bank to pay your money. And usually because a debtor and creditor's relationship is counted by interest. You will, if a bank refuses to pay your money, you should collect your money back from them with interest. That is one of the things that GT Bank did with Innocent. I don't know if you remember the story a few years ago. Innocent sued GT Bank for withdrawals they were doing on his bank account. And because Innocent, being a customer of the bank, is a creditor to the bank, he calculated the interest of the amount that they've been deducting from him. The interest he calculated it on is the interest the bank would have used to charge him for any loan he had taken from the bank. You realize now that if you want an overdraft from a bank, the roles of debtor and creditor has reversed. You are now the debtor, the bank is now the creditor. What does overdraft mean? If you're a consistent customer of a bank and you use, let's say, a current account, you've been using an amount of money steadily, there will come a time that a bank can give you a window of credit. If you are somebody who uses 1 million every month, the bank can allow you to take more than 1 million. So you can still write a check even when your 1 million has finished in the bank for, let's say, 10% of the amount you constantly spend. So bank can give you 100,000 naira over your 1 million, so that by the time you make your next lodgement of 1 million, they can remove it from there. However, that money they give you, they will charge interest on it. Now, it is in that nature, under that paradigm, right, that Innocent charged GT Bank uh, interest for the long period of deducting money from him, and the money became so much, you know, and that was what led to his problems with the bank. So it is also the banker-customer relationship is also a trustee relationship. How does a bank become a trustee for you? What does a trustee mean? A trustee is somebody who holds something on behalf of another person. If, for example, you are not up to 18 years, like some of you in this class are not, if your father gives you money, the money will not be handed to you directly. In what way? If, for example, your dad has a company and he wants you to take over the running of the company, and he will makes you the owner of a company, you cannot start running the company because you are less than 18 years. However, what will happen is somebody that is a trustee will run that company on your behalf. Any money that is made, the person will hold the money for you until you attain majority. That is an age that you are legally able to handle responsibilities of that nature. The person who is your trustee has the right to give you an account of how he used the trust property and other things of that nature. How does a trustee relationship occur with a bank? It happens this way. Take, for example, that you want to buy something and you use your bank. For example, you want to buy foreign currency. You go through your bank. Your bank has the responsibility to keep that money that they buy for you in trust. I'm just giving you this example. There are more complicated procedures where your bank can act as your trustee, especially for people who do importation on large scale, people who need letters of credit, investors, and merchants. Banks act as trustees for them. Fiduciary relationship means bank acting in utmost good faith. It is usually an offshoot of a trustee relationship where a person who is in a fiduciary relationship with you relates with you as somebody who has your best interest at heart. If he does not, you can sue him for neglecting his responsibility. This also arises in the kind of situation I've mentioned, where, for example, you want to buy a land or you want to do something and the bank advises you, this is where I want you to invest on. Let's say you go to a merchant bank, you want to invest in shares, and they have all these things in banks, but many of us don't know because we are not even rich enough to buy shares. You can walk into a bank to get advice on what shares you can buy. A bank can advise you, buy that share, buy this share. In that nature, he has to advise you in your own best interest. If it is proved that he's advising you based on what they can selfishly gain, you can sue them. Principal and agent. A bank can be your your agent, and the customer can be the bank's principal, especially when uh, a bank is giving instructions on what to do for a particular customer. You are going to find many of these examples in the textbook. Okay. The duties of a banker. What are the duties of a banker? I have to run. We have just 7 minutes to conclude this class. I don't want to come back again. A banker must honor the customer's checks. Remember that checks now also includes withdrawal slip and the money you get from your ATM. It just means that whenever you step up to say, I need my money, the bank should be able to give you your money. The bank can also act as a collecting banker for you. What is a collecting banker? We are going to understand what a collecting banker is when we deal with negotiable instruments. However, a collecting banker is a banker that handles your request. Let me give you a practical example for the purpose of just introducing this concept. If you have a bank, let's say you bank with GT Bank and I bank with Zenith, and I write you a check, you go to Zenith to catch the check, but it will not be given to you physically. I want the instruction I gave is to move that money from my account in GT Bank to your account in Zenith. Zenith Bank becomes for you, their customer, the collecting banker. They collect money from GT Bank on your behalf. So your banker can act as a collecting banker for you. Also, your banker has a duty to keep everything about your account secret. That is why the bank will not scream out your worth. Say your money is now 200 naira. You can't go to a bank cashier and say, I want to check my account, and they just scream it at you. It's 200 naira. They can't do that. They won't also give you in a document that anybody can see. It has to be closed so that only you will know about it. Another thing is to exercise care and skill in handling a customer's affairs. It should not be that a customer suffers wrong due to a banker's inability to handle his affairs with professionalism. It should not ever arise. That situation should not ever arise. Okay. What is the duty of a customer? The duty of a customer is to keep the checkbook he has been given well. So if, for example, the customer has a book that has been given to him that he can use to withdraw his money, a withdrawal slip, or an ATM card, you have a duty to take care of it so that somebody does not tamper with it. And where somebody tampers with it, your duty is to immediately report the bank as soon as you hear or you notice that your details has been compromised. The reason for this is if if your money has been scammed from you and it cannot be proved that you played a part in making sure that your money was scammed, the bank has the obligation to return it. If your money in the bank is scammed and it cannot be proved that it's connected to you, the bank has the obligation to refund you your money. So we'll deal with this more tomorrow. By the grace of God, we are way out of time. But yeah, it can only, where you are under duty as a customer not to receive any compensation is if the direct act of loss you face can be traced to your own attribute, something that you did. If it cannot be traced to what you did, then the banker cannot say that he doesn't have responsibility to pay you your money. Now, I want to show you a document produced by the CBN that talks about a banker and a customer's relationship. I'm going to post this on your Google Classroom page. So I have only 3 minutes. So just look at this. The CBN on his website calls it a bank customer's bill of rights. So you have to know this because these are your rights. As a lawyer, you can use this one to shine when you go to the bank. So you have a right to be informed, right? You have a right to choose. You have a right to safety. You have a right to privacy and confidentiality. You have a right to redress. You have a right to good service. You have a right to equality. You have a right to free monthly statement of account. Every month, your bank should give you a free statement of account. Your duty as a customer, you have a duty of knowledge and understanding. Nobody is going to give you this. You have to go and search for information about your bank. You have a duty of financial obligation. That is, if you go and collect loan from a bank, you have a duty to pay it back. You have the duty to protect your instruments and information, especially private information, your checkbook, your ATM, PINs, passwords, codes, all these things we use today for banking. It is your duty to protect it and keep it safe. You have a duty to provide factual information and not mislead the bank. You should not lie to the bank. They say, what's your name? You give your father's name. You shouldn't do that. It's a crime, self. You have to report suspected fraud or error. Is your duty. When you suspect a fraud, report it. You have a duty of personal safety and safety of assets. So this duty of personal safety is shared between you and your bank. So your gadgets, your things that you need to keep safe, that your bank cannot keep your phone safe for you. You have that duty. So the people presenting tomorrow, this has actually made your work very easy. All you need to do is to add 1 or 2 cases that will make this worth the while. Okay. So I want to say that today we have learned that a banker is a person who does banking business. A customer is a person who has an account to the bank. A banker has a duty to the customer. A customer has a duty to the bank. And the nature of their relationship legally is characterized as contractual, fiduciary, creditor and debtor, and trustee. So I will thank you all for coming. This is where we round up, and I will see you tomorrow evening.
Yeah, thank you, Baba.
I'll take your questions then. Thank you so much.